not to be construed or relied upon as being legal advice for an individual legal situation, or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
I'd like to welcome you all to this February 1st, 2011 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. So why don't we open it up for some Q&A, and we'll get right into that.
Q&A session started.
Anybody have a question, press star 6 followed by a 1. Star 6 followed by a 1. Questions, star 6 followed by a 1. Anybody? Texas, you're unmuted. Texas, you're unmuted.
Oh, man. Sorry. Thank you, Christian.
Hi, Al.
Albert in Texas.
Hi.
It's like I can't get this phone right. Okay. Question. This is an out-of-court, called an official hearing that this person is going to be going to in March. And the person, through, I guess, the last several periods of time that they were doing their process, putting in their statements and medical, this was dealing with a claim. Once everything wrapped up, now everything's going to an official hearing. The trustee in the matter got a lawyer, and the lawyer sent as exhibits all this person's evidence, using their evidence, that person's evidence against them. And you were talking to Marshall just a few calls ago, and my phone went dead right when he was going to explain what happened to him in court and when a lawyer uses your evidence against you. So I was hoping you could make a comment on that and tell me what you think about it.
All right. So how are they using that evidence against them? What's their charge? What are they claiming?
Well, that's another secret. They didn't come out because it's still 2 months away. They didn't come out and make the statement, but there has not been a lawyer involved in the whole process from the beginning. And now there is, and they've exhibited all this person's paperwork, and they're using it against them as a you versus them. It's the way they have it on there.
But how are they using that paperwork against them?
Well, the fact that they got a lawyer and using the very documents that this person was making a claim on, well, being a lawyer, I know that it's not going to be good for him.
I can't answer your question until you tell me what the other attorney's claiming.
That they're going to use that paperwork plus the very people that made verification of the claim that the employer sent this person to. They're using them as witnesses against this person.
Well, what's the charge? Claim.
They didn't say yet, other than just denying the claim.
Okay.
They're making NOIs without any SOI.
How am I going to defend something I don't know what the claim is or don't know what the charge is? I can't do that.
Well,
they're just rattling swords and saying they're going to come at you and they're going to use your evidence against you.
I don't have a rule of evidence book, and I just got this paperwork from this person a couple of days ago.
What is the actual evidence they're using against them? Is this going to be the debtor-creditor contract?
Well, yeah, this person is in a DC contract. I mean, there's no doubt about it.
And what they're doing is they're saying, hey, we're going to treat it as a debtor credit contract, and we're going to use this against you. So that's what they do all the time. So I wouldn't be afraid of that. I would not be focusing on the debt side and acknowledging the debt side at all. I would be acknowledging the trust side. I would be continually focusing on the trust side and bringing the trust side forward. Get them to argue your trust acknowledgement, not you arguing their debtor credit contract.
Right. I totally agree with you. What I was planning to
have anything to fear unless you get off track.
Like
don't have anything to fear unless you get off track.
Well, see, I never got to hear what Marshall said, and I don't even remember the date of the call, but it was not long ago, and he said the very thing before my phone went dead, and I never got to hear what he said. That's why I'm asking you.
I don't know what he
say something
about what that time was. It was concerning his case that he's got or something?
Well, he said that the attorney came in and was using his evidence in the court. Now, this is not a court setting, but it's like since it's official, and the last one. And what I was, I was thinking of doing is wrapping this up like a present for them, but first I wanted to just understand what Marshall went through, and you were coming in telling him to explain, and then my phone went dead, and I didn't get to hear it.
Well, I would suggest maybe go back to that recording and listen to that audio that you missed.
Okay, well.
I don't know exactly what he was saying, but is this you say this is an official hearing, but it's not in court?
Right.
All right. How does it become an official hearing? What is the authority for this official hearing? Is it like an administrative hearing or something, or was through a court and then they set it to arbitration?
It's recorded. This is the first time any of the meetings have been recorded. This person has just been hopping around like a rabbit with this stuff, and finally I told him, eventually it's going to come to an end, and you'll either have to learn how to make your claim or just let it go. Your choice.
Yeah, it comes down to you have to own the technology or know what you're doing, which are synonymous, or else you can't. And then they accusations and beat you up with accusations and make threats against you, and you're hunkering down and scared in fear.
No, well, see, it didn't scare me. I laughed when I saw it was like 120 pages thick.
Yeah,
and it was all
really
all this
can't help somebody else. They have to help themselves, and the way they help themselves is they got to get on these calls. They got to understand these documents. They got to understand the process. They have to understand it all themselves because they're the ones that are going to be in the hot seat in court. They can't rely on you to do the paperwork for them and then shove it to them, and all they got to do is sign their name. It ain't going to work that way. They're going to get hung.
I know. The days of holding your hand is over.
Yeah, we got to be adults about this. Adults know what they're doing. Kids don't know what they're doing. And that's how you become the age of majority, whether you want to accept the responsibility that you have to know this stuff yourself, not Albert.
Yeah.
Albert can't do it for you. Christian can't do it for you. Nobody can do it for yourself except you yourself. That's why I don't like people, because I can't help people. People have to help themselves.
Yeah. What I was saying is I could help this person greatly in that meeting, but I told them they'll shut me down quicker than a frog.
Yeah.
In your throat.
Yeah, because if they don't know what they're doing, you're going to be saying something that you shouldn't be saying, and then you're not going to say something you need to say when you need to say it.
Yeah.
And if you don't understand verbology and the statements to make under trust, then you can't hold an equitable side court, and you're going to lose.
It's been a while for me, going into these court things. I've stayed away from it pretty much, and the neighborhood I live in, it's private cops, I guess. I don't know. Anyway, they leave me alone after the incident I had with them in court. And like I said, I almost made my claim in that court. I just wish I knew where the other buttons were at the time. Like I've been out of it for a long time, and I just didn't know what else this person could do. I told them not to worry about it myself, but eventually they're going to say something, and you're going to have to say, well, where's your proof? Whatever they say, it doesn't matter. In fact, if it's a lawyer, you could try and get them out. They don't have any eyewitness to anything. But, like you said, you have to learn how to make your own claim and stand up for yourself. No, you're right. No, this process is not that hard. It just seems that way because it's different. Totally opposite of what everybody's grew up to learn.
Right. Yeah.
I understand that. I just wanted to see if you need that rule of evidence that I could just throw at this person just for them to be able to play with that, like a little kitten. But, it's okay.
He who sleeps on his rights has none. We can't be sleepers. We got to be awake. We have to be able to defend our rights, or else we have none.
Well, I've been eating commingler sandwiches for a little bit now. Can't help these people. They've finally reached the pinnacle of the claim, and now's the time. They've had plenty of time listening to you too. And
that's the trouble with today. Everybody's sleeping.
Yeah, they're afraid. Intimidated.
Only because they don't know the power that they got.
Well, thank you,
Chris. The ones
Christian.
that put everything into motion are the ones that gave them the authority. Now, where did they get it from? They got it from you. If you gave it to them under trust, you can take it back.
Hey, today I learned that I've been involved with something called the RT, and now I know what it is. I give it a new name. It's called Rabbit Trail Republic. These folks are just hopping like rabbits all over the place. I had told you a few months back about the executive letter, and you had a good thing on that one, and that's great. I'm glad you brought it all out. And now there's a new one. It's called Be a Man document.
Be a Man document. And how do you do that?
I think they ought to put a little woo in it. Not everybody's a man. Anyway, I just thought I'd, let you know about it. Anyway, I got to get out of this Rabbit Trail Republic, man. I always wanted to move to Florida.
Well, that's very easy to get out of the rabbit trail. Is you stop acknowledging the debt side. That gets you out of the rabbit trail. And you start acknowledging the trust. Because anytime you acknowledge the DC relationship, you just keep feeding the DC relationship. And we were talking about this the other day. The more force that you put in up against the DC relationship, it's like a rubber that comes back and bounces right back into your face. With the same force that you came at it with, it comes right back at you. Because you're the one that's giving the energy into it, and the energy is being redirected right back to you.
I really enjoyed Eric's teaching on yesterday's repudiation part of the equity. And unfortunately, everybody had a bad signal for some reason, and he didn't come out very clear. And that was a very good teaching, man. I'm hoping the recording is much better than what we've got over the air. But if not, maybe Eric should consider just doing a recap on it, because it was really good. Anyway, I'm still reading that book. That book's amazing. It's got a lot of stuff in it. Everything we've been talking about for a year is all in that book. It's amazing. You've heard of an author named Houston, right?
Houston? Yeah.
Okay. He's got a book, and I found it a few days ago, and, it might be in your arsenal already. It's called Enforcement of Decree. And it's like, I don't know, maybe 200 or 300 pages. And he just goes on and on and on about enforcing decrees, giving different areas of enforcement. And go ahead. Anyway, I just got the book, like I said, and it's not bad. It's not bad at all. In fact, I just read 10 pages and skimmed through the rest just to see what he had, and he just goes on and on. And I think it'd be a good read for more fresh eyes,
Yeah. Mm-hmm.
Okay, that's all I had.
What was the year of that book?
It's 1912.
1912? Okay, right.
Yeah.
Changed the rules of equity then.
Right. And if I can find the link, because I always bookmark the links on these things, you never know. You do a search and you get like 300 gazillion books, and I just skip around, and I get excited about it. Anyway.
It's in the Skype chat group.
Yeah, well, I didn't think anybody would be interested at first, so this is the first time I thought I'd mention it, and I'll throw the link out there.
Yeah. I mean, that's enforcement for decrees. First, we have to get a decree. That's
right.
one thing, but then...
Yeah, this is, it's called Enforcement of Equitable Decrees.
Enforcement of what kind of decrees?
Equitable.
Oh, equitable decrees.
Yeah, from the Court of Equity,
Okay.
from the Chancellor. He's a Chancellor.
Oh,
That's what he calls himself on that. You know, he was a retired Chancellor or something. And he also cites Gibson. He cites Pomeroy. You know, he cites all our readers.
well, we're all looking for enforcement, so.
Yeah, right. Okay, well, I'll do that, and you guys can look at it. All right, thank you, Chris.
Okay, Albert, thank you. Star 6 followed by a 1. Anybody? Raise your hand, get in the queue line. Star 6 followed by 1. Nobody else. Got a clean board. Nobody wants to enter in on the discussion. Star 6 followed by 1. Anybody? Star 6 followed by 1. Anybody? Maybe the shortest program in the history of NTT. Anybody got any questions? I got stuff to do. I'm ready to leave right now. Nobody got any questions? Questions, comments, anything? Going once? Going twice? Yeah, Albert, go ahead. Albert, you're unmuted.
Here we go. You hear me?
Yep.
Chris?
Yes, go ahead. I can hear you.
Yeah.
You're going to have to oil that button.
Oh, what can I say, man? It's a different phone. I'm always borrowing phones from people. Anyway, we've been discussing writing our bill in equity so that way we can go straight into that door rather than playing the at-law side. And I thought maybe it'd be a good time to ask you whether or not we should discuss in seeing, you know, an example of a document that we would write to go right into that B door.
Yeah, that's kind of like what the money call was supposed to be on the TAs were doing that when they started out with that equity book, how to really write a bill in Chancery. But yeah.
Well, is it safe to say that right now the best thing is the switches, colorable, something colorable, and then the switch?
Well, one thing I'd like to make clear is that there's been a change in where we thought the position of equity was, because it you know, all in the past we've been talking along. We want to get into in-camera hearing, in chambers to do an equity hearing, and we thought that in that at-law side court there was only one particular place, which was in chambers, where we're going to get equity. That view has been changed. I'm no longer of that opinion. And what really changed my mind on that was that Hendrickson versus Maxi Center case, Hutchinson's versus Maxi Center case, where it plainly spells out that there are two separate courts within the court system. Now that means that on the at-law side, in chambers, where we thought equity was, that wasn't really there. The equity side is in its whole separate venue, separate from equity, separate from at-law. Whole different venue, two streams. Two venues, two jurisdictions, two streams. And that whole case in equity, not just in chambers, the whole case, once you get it into that stream, is all equitable. And we don't have to go into an in-chambers or an in-camera hearing in equity, because the whole case is in equity. That's the extraordinary jurisdiction. And it's separate and segregated from the at-law. So I'd like to make that perfect distinction, way of thinking about it. That's the way we used to think about it in the past, that it was in camera and in chambers at law. No, it's the whole equitable jurisdiction by itself is equitable, not just in camera on that side, but the whole thing. I'd like to make that distinction first. So everybody, that's a correction of thinking how we used to think before. That's probably the first major correction that we've ever made. So now how do we get into that? And that's, since they combined the process, or the procedures into one form, and then it's what you put on the form that invokes whether you got that one jurisdiction in equity or the other jurisdiction in at law. So it's really the way that you put the bill together, or the pleading, that is invoking one jurisdiction over the other. So yeah, you were right, the equitable switches, but now which particular equitable switches were you talking about?
Well, I would think that if you had to go to court to start a fight, I'm just using that verbiage to say you're the plaintiff. Well, if, right now I have not seen a bill, so I can't really comment as to how Gibson puts it out can dissect what he's saying. I understand what he's saying, but I'm the kind that I need to see a sample of something. I got to taste it.
Well, the Gibson books is full of samples. There's plenty of examples there. And what I'm starting to see is it's not that a lack of examples. It's really a lack of understanding of the examples you're looking at.
Yeah, maybe so.
We don't lack examples. We need the understanding to discern what we're looking at and how to manipulate what we see. Most of us
you're way ahead
when we're looking at it. But those,
what I'd like. Go ahead.
The Gibson book is full of prime examples to be using, especially under that section under the trust, under the index, under the trust. Different sections in there, right around section 900, 928, and through there.
Yeah.
But it's full of.
Well,
full
it
of it.
was a long time ago, right? Wouldn't it be a little different today?
No, I don't see much different today, other than what they're using on the at-law side and what that's in that book. Still looks like heading. Still got defendant and claimant or plaintiff. Everything's paragraph style. State your claims, and there's a relief section, and I don't see much difference. And it's more modern in its form than, say, like that first one that Marshall and Eric were going over, that one with the big long title name. That one was really different, and that didn't look like the modern pleadings we use today. But this Gibson book on their 1907 version looks more like what we're doing today.
Take a look at that equity number 9 in Gibson.
Equity number 9?
Yeah, where it talks about equity will act for the disabled.
Section 9?
No, it's equity maximum number 9 in his book, where he outlines, maybe 12 maxims or so more. I saw 10, and I saw number 9, and I think someone on Skype, I just, trained for saying the names, but he brought it out, and I looked at it, and that right there, we discussed what disabled was about 7 months ago.
Yeah, right.
And I hadn't seen, an equity stating that, where you can help the disabled.
What page is that on?
Gosh, you got me, man. I didn't think I was going to ask you this question. I asked it on Skype, and nobody made comments, so I didn't think anybody was interested. But it's been there, where Gibson puts out, maybe a dozen maxims, and it's number 9.
Well,
and it could be
number section 31 through 40, and the 9th one is 39, which he who seeks equity must do equity. Is that the one?
No, equity acts for the disabled, and then it has, dot. There's a little bit more to it. I got it. I'd have to go look at the computer, and I'm in another room talking.
All right, that's when parties are disabled to act, Chancery will act for them. That's section 35. That's the 1, 2, 3, 4, 5th. That's the 5th one. Section 35.
I thought it was number 9.
No.
Oh, well. Well, that's a very interesting equity. Maxim, because that's what we were discussing back in April, May, is whether or not, should any of us, finally arrive, if we could help, say, our friend, our cousin, our brother, our sister, our mom, our dad, or whatever.
Yeah, that would be good if we could answer for them, but if they ever had to answer for themselves, I'm afraid they'd stick their foot in the mouth.
Right. That's true. That we brought that out, too, on that call. He brought out how
actually
why shouldn't
because they're still infants. They can't speak for themselves. If you need to have somebody speak for you because you don't know what to say in court, then you're an infant and you need to be not even going in there because you're a ward of the court. See, people got this wrong concept of, most of the people, let's put it that way, have the wrong concept. They think it's somebody else is going to do it for them. Can't do that. The sovereign the king does not have somebody else do the stuff for him. He decrees things done for him. So in other words, he knows and he orders what he wants done. I've seen many people say they get everybody else to do their work for them, and then when they get put on the hot seat, they can't defend any of it. And I know one fellow personally that does that all the time, and he is now in jail. He has everybody do everybody's methodology. He's created fruit salad, thrown everything like spaghetti against the wall, and nothing has stuck. He tries everybody's methodology except for the trust stuff because he couldn't grasp the trust. In fact, he did a semblance of that, but even that wasn't even effective because he couldn't back it up. He can't back any of this stuff up. And now he's in jail for 36 months. This stuff,
No, I understand your point.
you're better off not using this at all if you don't understand what it is and can't enforce it. You're better off losing your house, fighting it under a litigation method, getting an attorney, and letting them take care of it and lose your house that way. Because if you use this stuff under the negotiable instruments, but doing the redemption method, the DC creditor stuff, you do that stuff, that will get you in jail sooner or later. I swear on a stack of Bibles that will. I know that for an absolute fact. Everybody that I've known has done this redemption method stuff has wound up in jail. Sooner or later.
Well, it's still an interesting maxim. You know, that's all I was trying to bring up.
Yeah, well, got me on a soapbox here on the infants here that are unable to for themselves, and here they are trying to act and stand up, and they don't, they can't. They're disabled.
Yeah, right. So they can become, if you can become a ward of the state, of the court, you can become a ward of a private trust, but the problem is that sooner or later, one day, you're going to be caught off guard, and
we're all wards. That's the problem.
Yeah.
All wards of the state, all don't have any rights. All we have is slave rights, and as soon as the slave wants to get free, he gets whacked. You know, they used to hang slaves when they tried to escape. You think that's any different from today when they throw people in jail that try to escape because they're trying to get out of the D.C. realm? You don't think we have total tyranny today, total anarchy, both at the same time? And those are two opposites of the scale. That to have both of that happen simultaneously, that's really an exceptional circumstance.
Okay, so what do you think that equity max points again?
Well, I don't think that somebody else can act for you. Like what they want to do is they want to be the guardian, and they want to act for you because you're the ward, and the court is the guardian. The government is the guardian, and it's not like I can act for somebody else or you can act for somebody else because you're not a guardian. You're a ward. So a ward can't act for a ward.
I'm not talking about being a ward, using that maxim in any way or form. I'm talking about, you finally getting out and with your private trust.
Yeah, it says the Chancery Court gives the remedy. If you can get into Chancery Court, that's the whole thing again. Back into the Chancery Court. Can you get into a court of equity? That's the thing. Can you enforce an equitable trust, which exclusive jurisdiction is in equity? So the Chancery Court gives the remedy and has the full jurisdiction to do everything necessary for the welfare of persons under disability.
Okay, so that equity maxim was really talking about the court. It wasn't talking about, private trust being a guardian or taking care of a ward.
Does the court at all times having the view the best interest of the parties and acting as would a prudent or considerate parent? So the government is the courts today, but yet are they operating equitably? But nobody really knows equity, so how would they know whether or not the courts are operating equitably?
Well, that's one of the biggest problems we have.
Darren, you had a comment you wanted to make?
Yeah, just like in the Maxi Center case, once we invoke our claim in equity, now doesn't the court have to appoint a special magistrate or judge, which one is probably more suited to hear equitable matters versus an at-law judge or magistrate?
Yeah, I believe if you came in and made the claim from the start, from the beginning, you might get a better judge under somebody who knew something about equity. But if
but do we have to invoke that? Do we have to or request a special magistrate, or is that on the court's own motion?
I would imagine you could probably make a request for an equitable judge, yeah. In fact, it's not a bad idea. Okay. I mean, maybe you might get one. I don't know if any of you know anything more about equity than the rest of the next one.
Yeah, I mean, you got to consider most of these judges they're at law. They, and just like I've told you before, here I have a judge that's a friend, and I started bringing the fact that there's two sides of the court. At first, he thought He says, should I Baker Act you? And I said, no, but then after I proved it, I validated my NOI with some SOI to show that there was, including the Maxi Center case. He goes, yeah, I agree, but no, I've never seen anything as far as an equitable action in any of the 8,000 cases that I adjudicated.
Yeah,
so that just meant is that if you got these judges on there now that are basically strictly and totally at law, I think we should invoke it to protect our right, because chances are the other ones, if anything, they're gonna try to wing it or get us back over to the at-law side, which they understand. Because what did we say, since 1933, there's only been about 100 cases throughout the United States filed in equity.
Roughly, yeah.
So I mean, you break that down to all the district, federal courts, and state courts. Chances are they might have heard one, maybe two cases in equity since 1933, and chances are that judge wasn't sitting on the bench when they did.
Right. Yeah, in fact, in Doyle's case, they said that the trustee said something about in 17 years he hadn't seen a case like this, or something similar to that.
There you go. Yep. So in order to maintain our right, I think that is permittive to doing that right off the bat, along with all our paperwork, do a separate motion for a special magistrate or special judge, whatever they want to call it. It doesn't matter. One that is schooled and learned in equity. We could even put that in our pleading too.
I guess you have to pull somebody off the Supreme Court and sit in on.
Yeah, they'd be clueless too. Except maybe what's his name? Scarrera? Who's the one U.S. Supreme Court judge?
Galila?
Scarrera? Starts with an S. It's S-C something. S-C-E-R? Oh, I can't even think. Scalia? I can't think of it. Yeah, something like that. He's the only one that I think that might know it.
Okay.
No, but that was my only thing. That's what I was thinking, because here you brought that up, and you're right that whole case was, the Maxi Center case, the whole court was converted equitably because the equitable claim was invoked. Thus, it kind of like turned a blue court into a red court, just changed color.
Yep.
Force of a different color. But the question is, did the same judge sit on the bench?
Yeah, one judge, I think. Two courts, one judge, yeah.
Because a lot of even these civil cases, they do have traveling magistrates or traveling judges. Some of them are retired, but there might be some out there that do have knowledge, and they call in and say, "Hey, can you hear this case?"
Yeah, it comes
just a thought
that the person in there has to know equity themselves, and that's pretty easy to do. You're talking less than 20 maxims, so. And that's what the court principles operate on. So if the judge is not doing something right, you can tell right away that he's not, doing something right, because you know what equity is.
Yeah, and that's just the real, but that's the one thing that we want to be sure. And I think if we invoke it off the front, hopefully the court is going to act, the administration of the court's going to act fairly. Now, there's also separate rules in each state, unless it's on the federal level. They do have rules of judicial administration that might be in those particular rules.
Could be. We never checked there yet.
I'll send you a copy of it. That's all I got.
Okay.
That was a good one. Thank you, Chris.
All right. Okay, we got a clean board again. Press star 6 followed by 1. Anybody have a question? Star 6 followed by 1. Anybody? Got a clean board. Star 6 followed by 1. If you want to ask a question, get in the queue line. State your name, where you're from. Nobody? Nobody got any questions? Okay, star 1, star 6 followed by 1. Doyle, you're unmuted.
Christian, if somebody else wants to talk to you or ask you questions, so I'll ask a question.
Okay, Don. Yeah, go ahead.
Let's go back and discuss a little bit about what you do. You've got a case going, and it's at law. Do you want to go ahead and do the motion to dismiss for lack or want of equity, and then proceed from that point? Will that effectively get us into the at-law current, the equity current?
Well, I think maybe the wrong maxim is there. It's like equity will not allow this case to fail for a wrong that's being done. And that wrong that's being done is really being done in against the equitable side instead of the at-law side. So if we're on the at-law side, we really can't get the case to say dismissed for a lack of equitable claim because that at-law side doesn't have any equity in it anyway. So the plaintiff that came at me has no equitable claims. I really can't dismiss it because he doesn't have an equitable claim. I need to be making an equitable claim and then transfer the jurisdiction because of that fact. Then he has no equitable claim, and that equitable claim needs to be heard in equity.
So now, by filing your original bill in equity in your counterclaim, is that effectively going to get you pulled back over onto the equitable current? Or is there something else that we're going to have to do to pull that in?
Okay, say the question again.
By filing the original bill in equity or your cross-claim or counterclaim or whatever you want to call it in equity, is that going to be effective in getting you into the equitable side of the work?
Yeah, it should be, because now you're going to invoke that equity side with your claim.
Okay. And by having the correct form, which is
now I can
we're working on.
Equity on the equity side, and then make that claim that plaintiff's complaint didn't have any equity and it needs to be dismissed. And nowadays, equity can give you at-law remedy as well as equitable relief. And really the understanding of that is because equity was the source of the creation of the at-law side, and it has jurisdiction over it because it created it.
Right.
And equity can give you both a relief in any judicial system because it's the source of that judicial system. And we don't really need to go into the at-law side, period.
Right.
Equity can give you not only equitable relief, but give you a relief under any other system that it created at all, whether it be common law, whether it be statutes and codes or anything. But see, what they've done is trying to do away with the equity and maintain the at-law. No, we should be doing away with the at-law and maintaining equity.
So naturally, they're doing everything backwards.
Yeah, because they want to fight up and argue about legal titles. No, we want to fight and argue about beneficial titles. But yeah, once you get an equitable claim in equity, then you could dismiss the at-law side or at least put a stay on it under that 3725 section.
Could you not put that in your one of your requests for relief in your bill? Put that in there and request the at-law side today until. Yeah,
that would be the exceptional circumstances was talking about, or exigent circumstances, because now you're going to have to make an affidavit in support of that because. Now you're asking for an injunction and joining the action.
So which might be the most effective way to do it? Go ahead and file your bill in equity and then file the motion against the other case or the at-law case for lack of equity, or do an injunction. Might be easier to do it the other way.
Well, I think I'd definitely put the stay on. That way that freezes the at-law side. They can't do anything until the equity side's heard. And then let the equity court decide on the dismissal of the at-law side.
So you're saying then go ahead and put in the request for a stay?
Yeah, I'd do that first and then come in for the dismissal. Had that dismissal heard next. Dismiss the at-law side because it doesn't have an equitable claim.
Okay.
And they might not want to do that, I don't know, because equity follows the law. So if equity's following the law, that's the at-law side. But even if you did lose on the at-law side, you still can win on the equity side. Because on the at-law side, you're arguing about the legal title, and the legal title is not the real ownership of the whole thing, and that's not where responsibility and liability comes, because you're not the one holding the title, but you are holding the titles, and you need to get rid of those titles because that makes you trustee, makes you the liable party, although you're not really the right party.
And your way to get rid of them is merge them and send them back to trustee.
Yeah, give the public notice of the change of status from the character and nature of being general deposit to special being trust, or at law to trust. And there's where that 1005 section comes in, where that's your immunity and your armor, because now you can't have process of service, you're not the party, you're not in the jurisdiction, and the whole process can't be applied to you. And it's all at law legal in its nature, and it doesn't apply to the beneficiary. And you're not the beneficiary. Somebody else is the beneficiary. You're not the trustee. Somebody else is the trustee.
Right.
it comes down to, you got the debtor credit contracts, whatever they are, you're still holding them, and if you're holding them, you're acting as the trustee on a repudiation, and you waived your beneficiary right.
Right. I think section here on section 925 talks about the. Well, I'll just read it.
714.
Yeah, page 714, section 925. Which says trust generally carries.
What page is that in the PDF again?
Probably about 740. The PDF 40.
All right, what's the section number again?
Section 925.
925. Trust generally considered?
Yeah, there where it talks about trust, you hold the direct and absolute dominion over the trust property in the view of the court at law.
About what sentence? Is that paragraph, second paragraph?
It's about the second sentence in that paragraph, third sentence of the paragraph.
First paragraph?
The first one.
So entrust the legal title and possession of the property in one person called the trustee, and the equitable title and beneficial use of the property are in another person called the city key trust or beneficiary.
The trustee holds the direct and absolute dominion over the trust property in view of the court at law.
Yeah, in other words, he can kick the beneficiary off the land if he's got a lease and the beneficiary is in possession, because the right of possession is in the trustee, and he's got the right to kick off the beneficiary, and that's on the at-law side.
Right. But in equity, while in the view of the equity, the trustee is mere steward to hold, manage, and account for the proceeds of the trust property for the exclusive benefit of the beneficiary. So there are, depending on what side of the court it's on, they have a completely different view of the trustee.
Correct. Yeah. One side the beneficiary is the slave, and the other side he's the real king.
So how is it that at law the trustee is the absolute owner, and then when you're in equity, the beneficiary is the absolute benefactor?
Because of the splitting of the titles.
Oh, it's because of the splitting?
Yeah. The legal title's in the trustee, and that's the at-law side, and the beneficial title's in the beneficiary on the equitable side.
Uh-huh. And
the two sides are in trust, and they can't be commingled. Beneficiary can't be seen at law, and the at-law trustee can't be seen, or let's put it this way, if he's trustee on a trust, he could be seen in the equitable side. But if he's an agent for the trustee as an attorney, then the attorney can't be seen. Because it's an in personam action, not an in rem action. At-law is in rem. Equity is in personam.
The very last sentence in that paragraph kind of tells or says what we've been saying all along. The courts of chancery have exclusive jurisdiction of all matters arising out of trust of all kinds, perhaps resulting in trust.
Yep, that's why we want to have our right attached to a trust so that we can express it through the chancery court, the court of equity, for the breach of the performance. So we want to tie all our obligations and our debts to a private trust enforceable in equity.
Right. So how might we do that in a practical sense? Say you want to do your electric bill or your water bill or all of your utilities. Do you have to do a special trust or an express trust with each one of these individual companies?
Yeah, what's the first thing it says in this book it talks about? You said it earlier. All about one thing, which is the key.
The special relationship.
Yeah, the relationship. The relation.
Relation.
In this book, that's the first thing that's number one on their list. They talk about the relationship first. They got to determine the relationship. And that's what Gilbert's book used to talk about also. All these other relationships look similar. That's why we must do the test for the relationship. What kind of relationship do we have here? Because the relationship is the key. Because if we have a trust relationship, now we have a special equity. But if we don't have a trust relationship, then we got a contract.
So now, if you go down to the utility company and you want to do a special contract or trust contract, are they going to want to deal with you?
Well, are you dealing with the corporation or are you dealing with the man?
Well, I would think you would want to go talk to the CEO and perhaps this scenario.
Office banking with him, because back office banking would probably be private in trust. And if you can get him to agree, that you can do a back office banking thing, then yeah. But what did we do originally? We all got electric bills. What relationship did you establish when you established this electric bill?
Well, let's analyze it. You go in and you sign a contract or a application, and you're receiving a benefit, and you're paying for it.
And then that would be what kind of relationship?
Well, that's a general. That's just...
Yeah, general debtor-creditor. Yeah. So if we've done that, and all of us have done that already, then we've already got an establishment of a definite relationship on the DC realm right from the get-go.
Right.
So either we've got to set up a brand new account and close this other one out, or get this one withdrawn and redeposited as special. I don't care which other way you do it, that you're achieving the same effect.
Right.
It really boils down to you got to have a new recognition on their part of this switched relation from general to not being special. And you got to get them to recognize that. You got to get them to agree.
So let's say you're having a conversation with the CEO, and he says, "No way in hell will I do this kind of relationship with you." Do you have a recourse?
Depends on whether or not you had a trust relation set up prior to going in there.
Well, in most cases, probably would have, unless you're living on the street or something, you would have an electricity bill and water bill and all that. So you would definitely have sort of a relationship. And in most cases, it would be a general relationship.
Yeah, if it was general, then you probably wouldn't have much grounds to stand on unless you switched it over to a trust.
But that would require agreement of the party, wouldn't it? Or could just...
Well, that's where the party in the trust needs to know that a trust relationship was being formed comes in. So you could walk in there completely off the streets to form a new account and talk to this guy and say, "Hey, I know what's going on. I want to form a special relationship with you under trust, and this is what we want to do." And he could agree to that or he could not agree with it. So if he didn't agree with it, I could still go back and set him up and get him into a trust, and then get him for the breach of trust and come back in for the enforcement on.
Yeah. So it might be better if you might explain to him that either way he's going to do it, but it might be easier for him to go ahead and agree to it up front rather than go through litigation.
Yeah, I think when we take our time and we do it right the first time, it's going to be like a sledgehammer blow shock to this public dominion realm that they are not the ones in control.
Right.
And that's going to be like a shock wave resounding all through that realm that somebody woke up. And now they know they don't have the power like they used to due to fraud and duress and all this. And now they have something to fear. It's like today, they don't have anything to fear on that outlaw side because they know they're the winners.
Well, they know that, or they have that false assumption that they're in control of everything.
Yeah, so when we as the people get up enough knowledge and understand that we can go in there and beat them at the game in a different court, and now they know that we know, now the emperor has no clothes, and the jig is up.
Yep. Only hope it's not too late.
Not too late until they killed me.
Well, if they don't collapse,
that's what Patrick Henry said. Give me liberty or give me death. The buck stops here. It's better to be at war and be a free man than to be a slave and not be at war.
Right now we're all slaves.
Slaves that don't know we're slaves, yeah. That's the sad fact. Don't know that you don't know that you're a slave.
But what are they always saying on TV, or, especially in the media, land of the home, or the free and home of the brave, or something like that?
Yeah, that's all brainwashing.
Everybody believes it.
Nobody thinks that, okay, if I was free, then they wouldn't be able to take my property if I really owned it.
Or they wouldn't be able to stop me when I'm traveling.
Right. Things just don't add up. We're not doing thinking.
Well, that's the problem. We're not thinking.
Yeah. So we're out to change that. One mind at a time.
Yeah.
Believe me, it's a slow process.
Well, it took a long time for us to get here. It took a while to go the other direction. Well, very good. That's all I have.
Lisa says check the welcome group out. She's posting all kinds of stuff in there.
Oh, okay. That's Lisa group.
Yeah, the NTT group chat.
Well, I appreciate your time. Thanks.
Yeah, I'm only human. I only got so much time, and I can't do this all the time.
Yeah. I just can't absorb enough of it fast enough.
Okay, anything else?
I think I'll do it. Thanks.
I appreciate coming on, Don. Donna Lee, you're unmuted.
Hi, Kirsten. How you doing?
Okay, how about yourself?
Oh, I'm totally exhausted. I pulled an all-nighter last night and staying up doing some stuff I had to put on the outlaw side. And I went to court this morning for one of the cases that my mother had going on, and it was just crazy. I mean, the judge went from mad and I could throw you out of this courtroom. have you thrown out of here to just, he got really nice and then he got really like bend over backwards helpful. It was so crazy. It was just crazy. And
They're all actors. They're all actors over there, you know.
Yeah, I'll try to explain what happened, but I don't know if you've ever been so exhausted you can't even sleep and just up for hours longer than you should be. I don't want to babble or anything. If I do, just eject me from the call, please. But
I've been there, done that, been there before, yeah. I know what you're talking about.
Yeah. Okay, so I had been in front of this judge a few weeks back, and the opposing counsel, this was for a foreclosure, commercial foreclosure, and the judge said that I could not speak, and I was just basically, I couldn't say anything, really. It wasn't like you could do like NTT or use any switches or anything like that. It's like, but it was still, I'm surprised they didn't put me out. But so anyway, I have another breach of contract with another company that my mother was involved in. And see, my mother never shows up for anything. She doesn't answer anything. I mean, these clowns had a arbitration out in California, and we're here in Florida, right? Of course she doesn't go, so they get default judgments against her, and they're unenforceable, so they're trying to get it recognized here in Florida, right? So anyway, I didn't know I was going to see the same judge I saw a few weeks ago, and this attorney, a different attorney, he says, he goes, that she can't be sitting here representing a corporation, and the judge is like, yeah, he goes, you can't. You really can't be here, but I'll let you sit in here and just, to see what's going on, right? I'm like, okay. And so the attorney starts speaking, and I object.
Right.
And the judge gets really mad. It was so funny. He gets so mad. It's like his face is like red. It's like it's going to explode. And he goes, you cannot speak. You cannot talk in here. And he goes, I could have you, he said, I could have you thrown out of this room. And the bailiff stands up, right? The bailiff was sitting down doing her nails or something. Now the bailiff stands up, and I'm like, okay. I said, but Your Honor, they served her, and they served my mother in her natural person, non-corporate name. And he sat back, and it was like he just changed. It was so weird. And he started getting nice, and he started asking about her health and everything, and I was like, I really played it up. I was like, well, she's going on 80 years old, and, she's just not like she used to be, and she's got good days and bad days, and, it's a crying shame. And I just put my head down and looked at the table, because we were in a room off from the court. And so, the attorney talked a little bit more, and then the judge asked me some questions, and I said, I've done this big whole 24-hour following all these corporations that the plaintiff had merged into, and it's just nightmarish. But I'm sticking to it until it's completely done. But basically, the plaintiff in this case was merged into. It was absorbed into another corporation, so it was a non-entity. I mean, it was like a ghost. It couldn't be a plaintiff. But 9-10 months after it was just a non-entity, it decides to file suit against my mother. Okay, so I had all that proof and everything. And then, so the hearing went on a little bit longer, and I explained things, and he let me explain things. And then the judge said, you cannot, he said, you can't practice law. He said, we can't allow it. And I said, well, I said, Judge, I said, would there be a problem? I mean, what's wrong with me being a amicus curiae or curiae or, friend of the court? What's wrong with me being a guardian ad litem? And I said one other thing, and I can't remember what it was. But, man, he just, totally, right after I said that, it's like it went 180 degrees. It was crazy. And I don't even know why it even came out of my mouth. I have no idea. But I just Dan had put the definitions on my Skype chat for me from Black's Law 4.
You probably made an equitable claim, because when you make a claim for a guardian or a guardian ad litem or amicus curiae, those are all equitable claims.
And it's like, you know what? It was like crazy.
Now you're not practicing law.
Right. And I'm sorry, go ahead.
I say you're not practicing law, then you're practicing equity.
It was beautiful. And, but anyway, I wanted to read these definitions off real quick if you don't have a bunch of people waiting.
Yeah, go ahead.
Okay, amicus curiae, a friend of the court, a bystander, usually a counselor, who interposes and volunteers information upon some matter of law in regard to which the judge is doubtful or mistaken. Also a person who has no right to appear in a suit, but is allowed to introduce arguments, authority, or evidence to protect interests. And I was like, yeah, I really like that. And then the guardian, a guardian is a person lawfully invested with the power and charged with the duty of taking care of the person and managing the property and rights of another person who, for some peculiarity of status or defect of age, understanding, or self-control, is considered incapable of administering his own affairs. So, and both of those have trust language in it.
Mm-hmm. Right.
So, I wish I could remember. I said amicus curiae or curiae, friend of the court, and guardian ad litem. I said one other thing, and it's going to drive me crazy. I have to get sleep before I recall what it was. But, and it's like, some friends of mine said, it sounds like also like I just shut off their arguments that I was practicing law.
Well, really, yeah, you did, because you're if you claim amicus curiae or guardian ad litem, you're not practicing law. So they can't have you practice law in there. But if you come in as a guardian ad litem, then you're under a trust, because that's a different relationship.
I wish I would have been able to record that. Because if I really wouldn't have believed it myself if I hadn't been there seeing it with my own eyes. And this is powerful stuff. It really is. So anyway, and it was really funny because I kind of built my mother up to be she's not that bad at all. I'll just put it that way. But anyway, apparently the attorney before the hearing had called her and told her, and I told her, don't answer your phone, but of course she answers it. The attorney for the plaintiff called her and said, you can't have anybody speaking on your behalf. And she goes, she's going to speak for me, and that's all there is to it. Hung up on her. So in the hearing, the attorney's bringing it up like my mother's such a bad woman. Like he called her and she just had no time for him, and she just got off the phone in a rush. And Judge, can we get her back on the phone right now? And the judge says, he goes, she didn't want to talk to you. No, we're not even going there. He said it was so funny. I mean, just totally changed, like he was like my best friend or something. But after I said amicus curiae and guardian ad litem, he put his hand up like, I don't know how to explain this. He put his hand like that. Okay, this is what we're going to do. This is how we're going to help you out. It just blew me away. And he goes, he told the attorney, he goes, go ahead and make an order for the substitution for real party and interest. And he goes, you put in that order that this woman here was not able to speak, okay? And that preserved right there for an appeal. You know what I'm saying? But he said her mother will have 20 days in which to answer it, and when that 20 days is up, he goes, I will look at all the information about the plaintiff, if they existed or not, and he goes, I will make my decision then. And I was thinking, you know what, that would be a perfect time. Well, we already have all the evidence to give to him to show that it was a ghost. It wasn't real. There was no standing. It's an unenforceable thing. But I think that would be a perfect time to also give him the sealed trust indenture for in the private in chambers. What do you think, Christian?
I'm thinking. They're going to give issue an order. The other side's going to issue an order for what again?
A motion for substitution of real party and interest. I already put in my motion in opposition to substitution of real party and interest. I put in a notice of appearance. And
so they're going to use the authority then to come in and speak then?
Well, I think...
he just ordered you to answer for her in the next 20 days.
Well, you know what? This is what he said, though, Christian. He said... and this was really weird, though, because I just painted my mother as someone incompetent, right?
Right.
But he said,
because she won't come in.
She needed to prepare the answer. He said he wanted her there to be able. He wanted her. He wanted an answer. He didn't say she had to do it, but he wanted her in court, and I could be there to help her in court. It was like a huge.
You know that a person can appear in court by paper?
Oh, yeah.
So have your mother fill out the paper the way you want it to make the defense her statements, and then file the answer into court, and that's her appearance. She does not have to physically appear before the judge. She can appear before the judge by motion. And if you're the amicus curiae or the guardian ad litem, then you can speak the motion, because the motion is signed by her and is her statements, and you're not practicing law.
Isn't that beautiful? Isn't that beautiful? I just love it. It was like, Christian, it was like I was the puppet master and I was controlling the judge with strings.
Mm-hmm.
It absolutely blew me away. I'm still blown away. I'll be blown away for a while. If someone told me about something like this, I'd be thinking, well, I really would have liked to have seen that,
Well, the guardian ad litem relation is a trust relation.
Oh.
It's a confidential relation. And that gets you into, if you can make that, or at least a statutory look-alike equity, even if you're still on the at-law side. But yeah, if she makes out the wording and signs the document, the motion, and it gets filed in the court, and then you bring it in and you read it verbatim, that was her answer and that was her appearance. She can appear by a piece of paper. And since that motion is a speaking motion, then you speak the motion. They're not your words, they're her words. She's appearing through you.
And here's another, also another option she would have, if they really wanted her there, is, I told her, I said, you could do the paperwork and come in, and when they ask you questions, just say you stand on the paperwork.
Yeah, she could do that.
Yeah, and if they say, is this your signature? She'll see she knows, my mother's brilliant. She's freaking brilliant, but she was old school. I made an agreement with the bank, blah, blah, blah. Total turnaround now. She knows what's going on. She's really disgusted. She was so indoctrinated and brainwashed for so long. Like if they, for example, if they asked her, is this your signature? She'd say, oh, that's a photocopy. How I can't vouch for that being my signature. She knows to do stuff like that. I've trained her well. But people need to start getting experience with this, and don't be afraid to go into court. Do not be afraid to go into court.
Pants on the same way I do. He brushes his teeth the same way I do. He's
right.
Just like I am. It's the same thing. Just because he wears a black robe doesn't mean I need to be scared of him like he's a Ku Klux Klan or something.
Right. Yeah, exactly. Because honestly, I honestly believe
they're just in their business according to their realm. You got to know how they do business over there.
Right. Exactly. It's like, it kind of reminds me of I can't remember if it's ants or bees or both or wasps, where there's like these little other insects that like let off the same scent as the ants and the bees, and they just leave them alone, and these insects can just get away with murder. Not have to do the work, like total parasites, right? It's like just just really get into jurisdictionary and see how easy it is. I mean, it's really easy. I mean, they really don't do anything other than motions and orders and hearings and certificates of mailing and or service, and it's a sequence. It's all laid out, and it's, thank God I found jurisdictionary, because we have to know some of the at-law part, but yeah, people just need to go in there, and it's incredible what these words do. And Christian, I've been listening to you for so long. It's like, I'm telling you, the words just came out of my mouth, and it wasn't intentional. I mean, it's just like second nature, which is so cool.
Well, you had a paradigm shift. You got a different character and different nature now. You're special.
I mean, see what happens when people listen to Christian Walters? Stuff will come out of your mouth. It's really good. It just blows me away. God, you guys are wonderful. I'm telling you right now. I am just, wow. It's so exciting. But,
well, take 2 aspirins, go to bed, and get about 10 hours of sleep, and call me in the morning.
I need to find some Unisons or something over the counter. I'm so tired. But what an exciting day. Very exciting. And
sounds like the judge gave you a second chance of redoing the whole thing.
I can't believe they even let me in the door. I can't even believe they even let me in the door for a second time. I can be very charming when I want to be.
Did he say specifically what she was supposed to answer?
Oh, the order that was it the order? Yeah, the attorney was supposed to write up an order to give to the judge on the motion for substitution of real party and interest. And my mother would have 20 days and he has to give her a copy. She has 20 days to put in, all her side and stuff. I mean, the judge can't sit there and say, and grant an order when the corporation wasn't even there was no standing. You can't do that. It'd be like having Casper the Ghost come in and be a plaintiff and take you to court.
Yeah, they have to have a hearing and give you an opportunity to cure if you didn't show up for the hearing, before they default you. So.
Well, I mean, for them to have an arbitration out in California.
Yeah, but that's foreign jurisdiction according to the states. So they have to bring that in on a trial de novo.
Trial de novo?
Yeah, because if they bring it under the Foreign Judgments Acts, it gets filed into the case, and then it becomes a whole new case, and then you get the chance to come in and redo the case. It's a trial de novo all over again. You can't just bring a judgment in from a foreign state. It has to be heard again as a new case. Now, if you don't respond in 60 days, then it gets brought in and deemed as adjudicated. And then they can bring it in from the other state as is.
Wow. Okay. Yeah, I've been having some really crazy flashes of really cool things. But I wanted to ask you something real quick. We've heard about a lot of people that go into court and say the court can't. They can only see corporations. They can't see you, the real man. But these people are just trying to. And maybe rightfully so, get out of victimless crime charges and stuff. But they're not. These people aren't trying to seek to get into private equity. You know what I'm saying?
Mm-hmm.
But if the court at law cannot see the real man, then wouldn't we have to? I know that jurisdictionary gives a really ludicrous example. Say for example, if someone calls you a pink elephant and you get really upset and you're like, I'm not a pink elephant, and then they keep calling you a pink elephant. So it's the same thing you've talked about, where you can go into court and say, I'm not a pink elephant, but you also have to have the statements of interest, right?
Yes, right.
Where
Proof.
You go to the doctor and you have the doctor say, no, you're not a pink elephant, you're a man or a woman or whatever.
Uh-huh. Okay.
How could we get into the private or in chambers or private equity if they can't even see us? Is my question. If they can't even see me at law, how do I get into private equity?
Well, were you on earlier when I was talking with Albert, and I gave the disclaimer of the change of view of what we used to think in the past?
No.
Where we used to think of and the at-law side that we were trying to get into in-chambers, and in-chambers was that magical area that was in equity. Well, I don't believe that anymore. I believe that equity is totally separate out from at-law. And it's not just getting into chambers in equity, it's the whole case in equity that is equitable. And we have to get the venue changed from at-law to equity. And when we do that, then we're in equity.
How would you explain how to do that if the plaintiff sets their law form?
In the bill, you got to come in with a bill, either an account of claim or as an original action as a claim, and come in as equity with the switches in the form, the right verbiage in the form.
Okay.
And then that whole case gets switched into equity. So it's not just in chambers on equitable side that it's all equity. No, the whole thing is equity. And then on the at-law side, in chambers is not where we find equity. That whole at-law side is at-law, period. In that Maxi Center case, that was the one that brought that out. Separate jurisdiction, 2 separate venues, and 1 court, 1 judge. 1 process. Form, but on that form, 2 styles of pleading, equitable and at-law.
Wow. Okay, well, you know what? I thought I would try to help expedite things with trying to talk to some trust attorneys or, someone that I could, gain their confidence and just say, look, what's the freaking deal here? How do we do this? How do we, just get it done? And so I was looking around on search engines today, and I actually found there's an attorney in Jacksonville, and he's actually a gun trust lawyer, where if someone wants to carry Class 3 weapons, it costs $600. They set up a trust, and the trust, it's a living revocable trust, and if you have any kind of weapon that the ATF uses Class 3, and you have a trust in place, then they can't come after you or incarcerate you or, anything like that.
Mm-hmm.
I thought, isn't that interesting? So the lady I talked to, Jennifer, she said that it is a private trust, but she said you have to send a copy to the ATF. So I was wondering, how is that a private trust?
Yeah, right.
I said, huh?
Yeah, it's a private trust in the public, but it's acting under an equitable lookalike or a private trust lookalike, yeah.
Yeah, well, she said all trusts in Florida are inherently private. She wouldn't hear of any statutory type of thing. Yeah, she said you sent a copy of the trust, the private trust, the living revocable trust is sent to the ATF so they could see that it's in place. And I said, well, it's a private trust, but the ATF sent a copy. I said, are the ATF a party to the trust? She said, oh, no, they just have to see a copy of it. And I was like, well, that doesn't sound like a private trust if they're not a party to it. It just sounded really weird. Yeah, but I thought that was pretty weird how people are using trusts to be able to carry weapons that normally others wouldn't be able to.
What's a Class 3 weapon?
I would say like a machine gun, or there's some new, what is it? Taurus, that made the public defender. They came out with a new gun called the Raging Judge, or some crazy name like that, and they're thinking about classifying that as a Class 3 weapon, and just all that stuff. But it's really interesting how people are going through trusts now to cover themselves from statutes. But
yeah.
It sounds like a statutory trust to me. I don't know. It sounds like a mixture. It's so weird.
Well, that's the power of trust, even in statutory realm.
Yeah. Oh, thank God you got into this realm. Thank God. Wow. Amazing. What absolute grace you and Lisa have and the TAs. It's just incredible. Just incredible. Well, I really appreciate all your time and help and everything. And I mean, if it wasn't for you, there's no way I would have sat in there and said things that just effortlessly, without even any forethought. I mean, that blew me away also. And it was all I could do after I came out with that spiel real quick, not to say something really stupid like, your honorableness or whatever. Because I try to act really stupid in a lot of situations because I get away with so much. But, yeah, it was like the whole thing was just bizarre. I have to write it down before I forget it, but I have to get some sleep first. Well, thank you so much. I really appreciate it.
Okay, go get some sleep.
Yeah, and you get all the credit for today, trust me. Thanks, Christy, and have a great night, everybody.
Thanks. Thanks, Donna. So, anybody else? We got a question? Clear board again? All right. Anybody? *6 followed by a 1. Anybody have a question? *6 followed by a 1. *6 followed by 1. Anybody? Going once? Going twice? Going 3 times? Last call. Okay. Let's call it a show then. See you tomorrow at 8 p.m. on the talk show number. So everybody have a great evening. See you later.